Well, good evening, everybody, and thanks for joining us again for the Colorado ENP Study Session Series. And tonight, Michael Berry is going to teach us about U.S. employment law. So thank you very much for being here, Michael. And I know that we have Connie Johnson here from the Colorado 911 Resource Center who is helping to bring this series. Connie, do you have anything to say for us tonight?
Welcome. Thank you for everybody for your participation and for your hard work at it. And there's a hockey game going on right now. Okay.
Well, now we know what season this is being recorded in. All right. Well, as always, we're extremely happy that you guys are here live. We encourage you to ask questions. Chances are, if you have the question, then anybody else out there listening will probably have it too, and they'll be grateful that you asked. So please take advantage of being here live, and I will turn it over to Michael. Thanks so much.
Thank you, Jennifer. Welcome, everybody. As we've mentioned in previous sessions, highly encourage you to purchase your own copy of the ENP Study Guide. Download the ENP Book of Knowledge from Nina, because almost everything we're going to discuss comes directly from that study guide. But there's so much information in there to get directly from the source as you prepare to sit for your ENP exam. And these study sessions are a great supplement, but shouldn't be your only source. So today's session is on U.S. employment law. Exciting topic. It covers just section 5.1 of the study guide. And I'll say up front, I'm not an attorney. I can't provide legal advice, but I like to think I understand at least the basics and how they impact the workplace. I'll also point out that if you're keeping up on current events, some of the laws we're going to cover tonight may have been impacted by recent executive orders. That notwithstanding, we'll continue with this curriculum and as designed, since that's what's going to be on the ENP exam for the foreseeable future. So starting with page 154 of your study guide, it includes a long list of significant and important pieces of legislation. We're going to go through each of these acts that's listed in your book, plus a couple more that I think are impactful, with the exception of 3 that are listed on that page: the Middle Class Tax Relief and Job Creation Act of 2012, Kerry's Law, and Ray Baum's Act. Those 3 are going to be covered in the next session on 911 specific legislation and FCC regulations. So if these are not 911 related, why are we talking about them? Because they're important for your workplace. And just like our sessions on human resources and administration, there's more to being in a management position than just the 911 system. By and large, these acts have to do with employee rights and working conditions. And I'm going to go out on a limb here and say that if you're participating in these study sessions, if you're interested in attaining your ENP certification, you're either in a position as a supervisor or management, or you're hoping to promote into a position of supervision and management. Now, these laws are the powers or limitations they place on you, me, everybody in that position as an agent of your organization. And you can have a huge impact on the success or failure of your center by knowing these or not knowing these. So let's dive into these pieces and see how they might impact you. Now, there doesn't seem to be a cohesive order to these acts as they're laid out in the ENP study guide, at least to me. So for this session, I'm going to follow Daryl's example from the previous Colorado study sessions and group them generally by a category. And hopefully this will help you better understand and remember them for the ENP exam by grouping them together like that. Some of these acts have been amended over time, some will build on previous acts, and some are going to be much more impactful and important than others. We'll try and spend a little more time on those impactful ones. And of course, as Jennifer mentioned, these sessions can be as interactive as you want. So feel free to raise your hand, type in a comment, unmute, and ask a question as we go along. If it comes to you, I'll do my best to monitor for that. So first up are our labor relations and unionization laws. Now, these acts deal primarily with the rights of employees to unionize and are some of our oldest laws that we're going to discuss. There's not a lot of unionization in dispatch centers throughout Colorado that I'm aware of, so you may never deal with these. But unions are very prevalent in other parts of the country, like my previous home state of California. And there have been a number of laws introduced at our state level that you may want to keep track of if you're in Colorado. And while I officially have zero insight onto what you'll see on your ENP, I did have a few questions on my exam, and chances are good you'll see at least a couple of these come up for some level of detail. So starting with the Clayton Antitrust Act of 1914. This was an amendment to the Sherman Antitrust Act of 1890, where that act focused on antitrust policies and prohibitions on businesses and organizations around exclusive contracts and unfair pricing. Clayton Antitrust came in and amended that act by including an exemption for unions, where they were not included as an organization prohibited from these actions. It also restricted the use of injunctions against labor forces and allowed for peaceful strikes and picketing. Basically, it was the first in a series of allowing and not necessarily promoting, but permitting unionization in labor unions. Next up is the Railway Labor Act, say that 3 times fast, of 1926. This required collective bargaining and prohibited discrimination against unions in the workplace. It was also, again, one of these very early pro-union laws, but it only applied to interstate railroad companies until 1936, when it was amended to include interstate airlines. So a good way to remember it, Railroad Labor Act applied to the railroads. Next up came the Norris-LaGuardia Act of 1932. And this was the first federal law that actually protected all labor unions. It recognized the rights of the labor unions and forbid federal courts from barring or issuing injunctions regarding their right to organize, strike, or use other forms of economic leverage against their companies. Federal courts also could not enforce what were known as yellow dog contracts, which were basically agreements from the workers to their businesses not to join a union or leave the union as a condition of their continued employment. Next came the National Industrial Recovery Act of 1933. And you'll see this referenced as the NRA, or some places you'll see it as the NIRA. And this was another act that sought to guarantee the right for collective bargaining for those unions. Pretty simple one there, but notably, this act was held largely unconstitutional by the US Supreme Court, which then led to the Wagner Act of 1935, also known as the National Labor Relations Act, or NLRA. This act brought back a lot of those labor and collective bargaining protections that they were trying to get in the National Industrial Recovery Act, and applied it to all entities involved in interstate commerce other than agriculture, government employees, and railways. Railways already had their own. It also notably created the National Labor Relations Board, or NLRB. And this was an independent federal agency to help oversee and monitor union creation and investigate and enforce fair labor practices around labor creations in various industries. Next up was the Taft-Hartley Act of 1947. And this was an amendment to that Wagner Act. You see how they're building on each other. Notably, this one was vetoed by the president, President Truman, and it was forced to go back through Congress for a majority vote. And that's largely because this is when things started shifting back the other way, and it was considered anti-labor. While maintaining the prohibitions and rights of the labor unions, the focus of the Taft-Hartley Act, or the National Labor Relations Act, was almost anti-union. It maintained their ability, and it did this by excluding supervisory staff from the Wagner Act. They no longer applied in that protection, and it prohibited closed shops which means union-only mandated memberships. You couldn't force somebody into a union. It also banned discrimination if an employee chose not to join a union, and created procedures for delaying or averting strikes that might be seen as creating a national emergency. If you think about when, for instance, FAA air traffic controllers want to go out on a strike, or in their day, the National Railway workers, it allowed for federal intervention at that level to avert those strikes and forbid those strikes because of the possibility of interruption of national transportation and commerce. Generally speaking, Taft-Hartley wasn't anti-union, but it certainly was not pro-union the way the previous acts, for instance, Wagner, that it amended. And last up in these Labor Relations Act is the Landrum-Griffin Act of 1959, also known as the Labor Management Reporting and Disclosure Act. And that reporting and disclosure is an important part of remembering this one because it's what differentiates it. This was created to provide for the reporting and disclosure of financial transactions and administrative practices of the labor unions and the employers to prevent the abuses in the administration of things like trusteeships of the labor organizations, and to provide for standards with respect to the election of officers of labor organizations, really ratcheting down on the administrative sides. So, any questions regarding the labor relations laws? All right. Next up, we have our employment standards laws. Now, I highlighted here the FLSA because this is a particularly impactful that we're going to want to talk about. And let's start with that one. So the Fair Labor Standards Act, or FLSA, of 1938, is a law you need to know for a few reasons. FLSA is also known as the wage hour law. And with the 24/7 nature of dispatch centers, this can be really easy to find yourself in violation of. The first area of impact is in determining which positions are subject to this act, the FLSA, or if they're not, or to say they are non-exempt, they are not exempt from this act, and which positions are considered FLSA exempt. They don't apply to these laws. Non-exempt positions are typically your line level dispatchers, your employees who track hours and are subject to minimum hourly wages and overtime pay for any hours over 40 worked in a week. Your exempt positions are typically your higher level executive supervisory positions. These are also known as salaried positions because their pay officially is based on a monthly or annual salary, not technically an hourly wage, although you'll sometimes see it broken down that way. These positions, these exempt positions, are also not subject to overtime. Their salary is their salary. And the assumption there is that they'll have roughly 40 hours of work per week, and anything above or below will essentially be a wash in the end. Now, there are special exemptions for law and fire employees, where agencies can average out the hours over 2 to 3 week period so that it works out to 40 hours per week on average. But it's very limited and very specific to those field sworn and operational employees, not to dispatchers. But you will see some agencies try and get away with that. Next up is the Occupational Safety and Health Act, or OSHA, of 1970. It's widely known for creating national standards for employers to provide for a relatively safe workplace. OSHA, the act, created OSHA, the administration, and the enforcement arm of that act, which publishes and enforces the general standards for safety. In general terms, OSHA makes sure employers are providing employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm. Pretty well says it right there in safety and health. Next up, the Illegal Immigration Reform and Control Act of 1996. Now, this was originally named the Immigration Reform and Control Act of 1986, but was refocused and amended in 1996, adding that illegal at the beginning of the title. This act provided for a number of changes and reformations around immigration law, including increased criminal penalties and enforcement measures. But most notable for our employment discussion, this act is what requires employers to conduct 3 types of employment authorization verification when you're hiring to ensure your applicant is eligible. Now, you may be familiar with your hiring process at your agency, where a new hire has to bring in various government identification, a passport, a birth certificate, complete an I-9 employment verification eligibility form that gets reported to the federal government. This is the act that caused that. Next, the Employee Polygraph Protection Act of 1988. This generally prohibits private employers from using polygraphs or lie detectors for pre-employment, discipline, internal investigation, and pretty much across the board. When it is allowed, it's very limited and very controlled. Since most of us don't work for private employers, this might not come up much for you. It might be a part of your conditional offer when you get hired, and that is still controlled by this. There's still restrictions, but for the purposes of our ENP exam, easy enough to remember: polygraph protection, very limited use rights. So any questions on these employment standards laws? All right. Next up are our anti-discrimination laws, including, as you can see with the highlights, particularly important, our Civil Rights Act and our Americans with Disabilities Act. But first up is the Equal Pay Act, or EPA, of 1963. Now, this is an amendment to the FLSA, the Fair Labor Standards Act, aimed at prohibiting discrimination based on sex in the payment of wages, equal pay, mostly based on gender. It does include 4 exceptions to allowing for wage differences. The first is on the basis of a seniority system, where you can pay more for an employee who's been there, for instance, 10 years versus a new employee. For differences in payments based on a merit system, where you can justify why and how that pay was earned. On the basis of measurements of quantity or quality of product, especially in places like manufacturing, similar to the merit, where you can actually point to specific criteria and standards for that pay difference. And finally, when you can justify the differential on some factor, some identifiable, quantifiable factor other than sex. That was the important part of the EPA. Next up is the Civil Rights Act of 1964. Now, this is a key piece of federal law that is likely to show on your exam, in my opinion, because it's one of those fundamental employment laws. The Civil Rights Act, specifically Title VII of the Civil Rights Act, prohibits discrimination in employment on the basis of sex, race, color, national origin, and religion. Now, this prohibition applies across from hiring, firing, compensation, similar to that EPA, and general treatment during employment, including any kind of privileges. Importantly, the Civil Rights Act only prohibited these 5 areas of discrimination initially. Now, you may be thinking about other areas of prohibited discrimination, but any other classifications, any other protections or prohibitions are covered in either amendments to the Civil Rights Act, separate acts in and of themselves, or perhaps even state laws and local rules. Also, the CRA applied only to employers with 15 or more employees, including colleges, universities, employment agencies, and labor organizations. So small employers with under 15 employees, think of your family businesses, your mom and pop shops as they're called, they were not subject to the Civil Rights Act. Now, the Civil Rights Act also created the Equal Employment Opportunity Commission, or EEOC, to investigate and enforce the provisions of the Civil Rights Act. as well as other discrimination-related laws as they were expanded throughout the years. The study guide legislative list references the Equal Employment Opportunity Act of 1972, but it's not included in the descriptions in the paragraphs within the chapter. So this is the 1972 amendment to the Civil Rights Act, but it's often spoken about separately as a kind of a standalone act. The Equal Employment Opportunity Act expanded the protections from discrimination based on age and disability, which we'll see highlighted in other acts as well. It also protected genetic information as a protected class. It also prohibited retaliation against anybody who reports a possible violation of their rights. And it allowed the EEOC to sue the employers directly for violations, where previously the EEOC just made rulings and investigations and allowed other individuals to sue themselves. Now, the Age Discrimination in Employment Act, or ADEA of 1967, is not specifically called out in your study guide as an act of its own, but I think it's important to point out and separate it because the study guide does include, and we'll go over this next, the Age Discrimination Act of 1975, and I don't want you to confuse the two. In the ADEA, Age Discrimination in Employment Act, when most people think of age discrimination, they think of discrimination based on advanced age. Specifically, when you reach 40 and over, you're part of a protected class. That is this act. The ADEA protects certain applicants and employees 40 years of age and older from discrimination based on their age in hiring, promotions, firings, compensation, or any terms, conditions, and privileges as part of their employment. The ADEA is enforced by the Equal Employment Opportunity Commission, the EEOC, which was created under the Civil Rights Act and is why most people think of that 40-year age barrier as being part of the Civil Rights Act. Under this law, it's unlawful for any agency to discriminate on the basis of age unless they can establish that the age limitation is a bona fide occupational qualification necessary for the performance of duties in the position. So what does this mean? In the dispatch world, or anywhere else for that matter, it's really hard to establish a reasonable justification for this kind of legal age discrimination. You'll see it every once in a while, particularly with forced retirements. You'll see it in air traffic controllers. They have an age requirement for starting and for ending. But it's really hard to establish that in basically anywhere else. And it doesn't matter if you think younger people can learn better or keep up with your CAD system, they can multitask better. Those are quantifiable skills that you can test for and monitor regardless of the applicant or employee's age. So best bet is to test for those skills and monitor that performance and not include any kind of age restriction, particularly over 40. Then we have the Age Discrimination Act of 1975. No E, just ADA. This is the one your study guide has, but it's easy to confuse the two. In this act, it prohibits discrimination generally on the basis of age in programs and activities receiving federal financial assistance, but it applies to all ages. That 40 doesn't matter for this law. In the Age Discrimination Act, it's enforced by the Department of Civil Rights Centers, not the EEOC. And under this law, that 40-year age limit doesn't exist. It doesn't apply. This is discrimination for any age, using age as the basis. In your comm center, maybe you think it's important for a dispatch applicant or a supervisor to have a certain level of life experience. You don't want to hire an 18-year-old right out of high school or promote a supervisor under 30 because they just won't get it. They don't have that experience. You can't do that. It's illegal. Age, either too young or too old, cannot be the basis of a qualification for hiring, promoting, special training, whatever. Again, skill, ability, reasonable experience should be your factors, having nothing to do with age. Next up is the Vocational Rehabilitation Act of 1973. And specifically, they point to Section 503 of this act, which prohibits discrimination on the basis of disabilities. Most people will think of the Americans with Disabilities Act, which we'll talk about, but that wasn't enacted until 1990. This act, the Vocational Rehabilitation Act, focused specifically on federal agencies, programs, contractors, and subcontractors with at least $10,000 in contracts with the federal government. Employers falling into this category not only were not allowed to discriminate, they actually had a legal requirement to take affirmative action to hire, retain, and promote qualified individuals with disabilities. And if you think about what was happening in the world around this time, the US had just signed their treaty to pull troops out of Vietnam in January of 1973, a conflict that brought home a lot of people with disabilities, and the government wanted to account for that in the workforce. So vocational rehabilitation was our earliest disability law. Around that same time, we get the Vietnam-era Veterans Readjustment Assistance Act, or VEVRA, of 1974. And like that Vocational Rehabilitation Act, it applied to federal contractors, and it prohibited discrimination and required that same kind of affirmative action to employ and advance veterans. For this, contractors were required to post their job openings with priority preference, special treatment for veteran applicants. And they were required to report annually on their practices in hiring and promoting veterans to comply with that act. Next was the Pregnancy Discrimination Act of 1978. This prohibited discrimination on the basis of pregnancy, childbirth, and related medical conditions to pregnancy and childbirth. This is one of those protected classes that some people will think of often when they think of the Civil Rights Act and sex discrimination, but it's its own unique act focusing on pregnancy and childbirth. And like other acts, this one applies to employers with 15 or more employees. Discrimination based on pregnancy can show in a number of ways, including refusing to hire someone because they may be or could become pregnant, or attempting to fire or otherwise penalize somebody for being pregnant or trying to go out on maternity leave. Now, the study guide dates this act as 1975. I think that's a typo. Can't guarantee it, but you're probably not going to be asked about the year. More importantly, just remember, Pregnancy Discrimination Act prohibits discrimination based on pregnancy. Now we get to the Americans with Disabilities Act, or ADA, of 1990. And this prohibited discrimination on the basis of disability across a wide range of employers, including in employment, transportation, accommodations, telecommunications, and just in general in public, not just for employers. This is a significant act with impact across the spectrum. And this is the law that requires your comm centers to continue purchasing phone equipment and training on the use of TTY and TDD to guarantee equal access to 911 services. It's through the ADA that we legally must offer reasonable accommodations during testing, hiring, and throughout the employment process. And that term reasonable accommodations is an important one. It doesn't mean you need to completely redesign your comm center or purchase $1 million software system to allow one person to feel better about their work environment. But your center legally must be capable of accommodating somebody in a wheelchair, for instance. If you have an otherwise qualified candidate with whatever disability, if they can be just as great an employee with a different headset or a special keyboard, not only should you consider them, but legally you must consider them and allow for that accommodation during testing and throughout the employment phase. And discriminatory behavior might not even be something that requires accommodation. What if you had an applicant, for instance, who only had one hand? It would be easy to dismiss them because of how much typing a dispatcher needs to do. But that's where the typing and skills tests come in during that hiring process. If the person can pass those skills exams with or without some level of commendation, why not give them the same consideration as any other applicant? Next up is the Older Worker Benefit Protection Act of 1990. Now, this is an amendment to that Age Discrimination in Employment Act, the one that specifically protected people 40 and over. In the Older Worker Benefit Protection Act, the emphasis here, as the name suggests, is on protecting the benefits. As an older worker, you might have a higher wage, you might have seniority. Maybe your employer wants to get rid of you and bring in somebody younger and cheaper, but they can't because you're protected by the ADEA. So rather than illegally firing you, they offer you an early retirement package that seems too good to be true. Maybe they embellish it a little or don't fully explain the terms of your early retirement. And that's where the Older Worker Benefit Protection Act comes in, amending the laws to require complete and accurate information in that offer. All right, any questions on these anti-discrimination laws? Excellent. Our final category tonight is on laws concerning employee benefits, including notably the Family and Medical Leave Act, or FMLA. But first, the Social Security Act of 1935. Now, this is not included in Section 5 of your study guide, but it is listed in the ENP exam breakdown. As you might guess, the Social Security Act created the Social Security Administration and the Social Security program, funded through payroll tax. Now, notably for probably most of us, if not all of us, a number of industries were excluded from paying into Social Security, including agricultural labor, domestic services, teachers, nurses, hospitals, and government employees, which most of us fall into. And that's why you won't see FICA, that Social Security pay tax, on your paycheck. And instead, you'll participate in some other retirement plan through your agency, your county, your town, whoever that might be. The Employee Retirement Income Security Act, or ERISA, of 1974, was created to protect retirement assets. Now, during this time, it was not unusual for retirement and pension plans to be used as a kind of private account for the people managing them, whether that's a union or a private account manager at a business. Now, the ERISA required those plans and those managers to be accountable for their participants with clear, regularly submitted information, minimum standards, and the right to sue for breach of fiduciary duty. Fiduciary duty means you have a responsibility to the people and the money, not to yourself. And in general, it attempts to protect participants from mismanagement and abuse of retirement accounts, as the name suggests. The Consolidated Omnibus Budget Reconciliation Act, better known as COBRA, of 1986, extended access to healthcare insurance coverage when a qualified event would otherwise cause a person or their family members to lose their insurance coverage. If one of those events happens, most notably when people think of when they leave a job, rather than losing access outright, you have the right to choose to pay out of pocket and continue your coverage until, for instance, you get a new job and are covered under a new employer's health plan. And this applied even through divorce, separation, and death for family members that could continue their healthcare coverage until they could find some other means. Now, the Family and Medical Leave Act of 1993, or FMLA, is another major law that will come up regularly in your workplace and is one that's often supplemented and expanded by both state laws and agency policies. In short, FMLA allows for an eligible employee to take up to 12 weeks of protected, unpaid leave during a 12-month period for certain qualifying life events, and their position or a comparable position will be waiting for them when they return. Those qualified events, as the name implies, are family and medical related. Basically, it's a law that assists us in a work-life balance. So qualified events included birth, adoption, or foster care placement of a child within 12 months of that event. So you couldn't take maternity or paternity leave when they're 3. It's got to be within that first year. You can care for a spouse, parent, or child with a serious health condition, just that core kind of nuclear family group, or caring for yourself, of course, during a serious health condition. And there are also special conditions for military caregivers that allows for up to 26 weeks in a 12-month period instead of 12 weeks, if injuries were sustained while on foreign deployment. So who is an eligible employee? An eligible employee is someone who's been employed for at least 12 months before and has worked at least 1,250 hours during that 12-month period just prior to the leave. For reference, as a point, 1,250 hours would be at least 24 hours a week for a part-time employee in that leading year. And it only counts actual work hours. And again, your state or your agency could have a much broader level of protection around this type of leave, including options for some level of pay or additional family members that it applies to, but it's not part of the FMLA, the federal act. Next up is the Patient Protection and Affordable Care Act, or ACA, of 2010. And this is another act that's not listed separately in Section 5 of your study guide, but it is included in the exam guide breakdown. It's also our newest law that we're going to review. And while you might recognize the acronym ACA, some people might know it as Obamacare as well. The ACA was a major overhaul of our health insurance system. But the biggest impact was on requiring insurance for people who had not been previously insured through wider access in online insurance exchanges and tax credits based on household income, as well as penalties if you didn't. Most agencies already offered some level of health insurance as part of a benefit package. And the ACA just set some requirements on the types of plans, the level of coverage that could be offered. All right, any questions on employment benefit laws? All right, again, I'm not an attorney, not even an HR professional, but the importance here is to at least have a fundamental understanding of these national laws, how they might come up in your workplace. And while it isn't covered in the ENP exam, I also recommend you learn more about your state's laws that can often, again, supplement these national laws. For instance, here in Colorado, you should know about the Family and Medical Leave Insurance Program, or FAMLY as an acronym, which became active in January 2024. And if your agency participates in FAMLY or provides a comparable internal alternative, it's going to drastically change how you handle those same FMLA-related leaves by going through different standards, different requirements. And if at any time you think you're running into a situation where one of these acts may apply, reach out to your agency attorney, your HR department. They're the specialists and the experts that can help guide you through it. All right, I know I've asked a few times. I feel like I get these short sessions that go by pretty quickly, but I'm happy to try and answer any questions you might have. All right, then. Thank you all so much for being here. Huge thank you again to the Colorado 911 Resource Center and the 911 Training Standards Institute and the State Colorado 911 program for putting these together. And don't forget to come back. It'll be in 2 weeks for session 12 for 911 laws and FCC regulations.
Thanks so much, Michael. Are you sure no one has any questions at all? That was a lot of alphabet soup, and I thought you did a great job with it. All right, we'll see you all in 2 weeks. What's that, Michael?
We do love our acronyms.
That's right. Well, thanks, everybody. We'll see you next time.